We won't have the benefit of a ruling from the judge on the Carter application, so we won't know whether that evidence, that body of evidence, is going to go in whole or in part or not at all. And we'll have to prepare our final submissions with that in mind.
Two developments came out today on the 38th day of the Chris Barber and Tamara Lich trial, which just came to an end. The judge issued a decision on a dispute over the breadth or narrowness of an evidentiary exhibit submission, and she also issued a decision on this Carter application timing dispute. Robert Kraychik here in Ottawa, Ontario, reporting for Rebel News. Chris Barber and Tamara Lich are being charged with a number of crimes in relation to their involvement with the Freedom Convoy of 2022, a massive demonstration in downtown Ottawa in broad opposition to what I regularly refer to as the COVID-19 enterprise. You all remember it, a series of orders, edicts, mandates issued by various levels of government, ostensibly in pursuit of so-called public health. The judge decided that she would accept one defense team's application or request for expansion of an evidentiary exhibit and deny the other. So specifically, that means that Tamara Lich's defense team requested that one video that she had produced in selfie format and published to her Facebook profile and submitted as a piece of evidence by the Crown be amended to include other videos that she had also produced, arguing that those other videos added additional necessary context within which to fully understand that video's statement. The judge rejected that and said that this video submitted by the Crown, again, produced by Tamara Lich, stood on its own merits, did not require extra context to be properly understood. Now, in the case of Chris Barber, there was a video that he had produced also in a selfie format and published to his TikTok profile during the Freedom Convoy that his defense team argued required broader contextualization via other videos that he had produced at the same time about the same theme in order to be properly understood. The judge accepted that. She said that, yes, those additional videos are required for proper understanding. We watched those videos yesterday. To give you some specific examples of how this decision came to be, it's a video that he produced about some burning of a Canadian flag that took place during the Freedom Convoy, and he had produced other videos in short order, maybe an hour later, 30 minutes later, to elaborate and expand on those developments and those messages that he was sending to his followers at that time. He was wearing the same shirt, had the same hat on, in the same location. So it shows you an interesting situation in which online statements published to so-called social media can be amended in a sort of ad hoc manner in a dynamic, evolving, unpredictable scenario, such as an ongoing protest or demonstration. So think of it, if you say something, it's not complete until that event that you're reporting on or commenting on in a live digital atmosphere comes to an end. The judge also decided to reject another request by both defense teams, a request to bifurcate, to divide, to segregate the timing of arguments provided over this Carter application. Now, just very briefly, to explain to you what the Carter application deals with, a Carter application is submitted by the Crown to apply a framework of conspiracy to the defendants and the charges. In other words, if a Carter application submitted by the Crown is accepted by the judge, the defendants are viewed as co-conspirators who are working in collusion towards some criminal scheme, some unlawful design. Now, the defense teams requested that the judge render her decision on the Carter application prior to final submissions from the two sides. But the judge said no, she wants them done in a consolidated manner at the same time. What is the practical effect on the defense teams? Well, they told me yesterday. Both Diane Magus, defense attorney for Chris Barber, and Lawrence Greenspan, defense attorney for Tamara Lich, said that it would make it easier for them, it'd be better for them to prepare their final submissions if they know what the judge is going to decide over this Carter application dispute. Now that the judge has rejected this request to separate the timing of the Carter application decision and dispute and final submissions, the defense teams basically have to prepare for both scenarios. So now they've got to do, let's say, twice the homework. and that will be continuing when the trial resumes.
Folks, it's undeniable that our rights and freedoms are under attack. The Freedom Passport is an easy-to-read, pocket-sized booklet containing the Charter of Rights and Freedoms. There's an app, too. Easily access the Freedom Passport on your phone and compare rights and freedoms from around the world for only $3.99. Visit freedompassport.ca and get your Freedom Passport today.
One last thing I want to share with you folks relates to observations I made during yesterday's proceedings, where there was this dispute over the breadth or narrowness of a selfie video produced by Chris Barber and again published to his TikTok during the Freedom Convoy. So in this video, he's discussing some sort of burning of a Canadian flag and advising his followers and supporters how to behave. Now, this is the important takeaway. He was regularly advising, guiding, directing his followers, his supporters, and his fellow Freedom Convoy demonstrators to remain peaceful. He uses that word over and over again, stay peaceful. He also repeatedly implored, advised, guided Freedom Convoy demonstrators and protesters to comply with police and law enforcement. Now, this, in my humble opinion, directly undermines the allegation, the charge of counseling to commit mischief. Chris Barber, not only in those videos, but in all the videos that we've seen across the proceedings of this trial, and I've seen them all, I've been here every single day, he was advising supporters, again, be peaceful and comply. He was counseling people digitally against mischief. He was counseling them against criminality, advising them to comply and adhere to police officers' requests and demands. So that's one major takeaway that we saw yesterday, and it is also indicative of a broader theme that we've observed across this entire trial, and that also includes several videos that were introduced as evidence by the Crown, produced and published by Tamara Lich.
The true path is hard, but it is the only way forward. You must fight for your ancestors, fight for your children, and fight for yourselves. The future is ours. The people are awakening to a force that cannot be suppressed. Glory be to freedom, glory be to Canada, and glory be to all of you. Thank you.
Okay, so Lawrence Greenspan, defense attorney for Tamara Lich. Similar question you were just asked. I'm curious if you would tell our audience about the rationale against introducing evidence in final submissions.
We made the decision. We elected not to call any evidence at the conclusion of the Crown's case. The case has gone on extremely much longer than we ever anticipated, of course, but the fact is that we made that decision on the basis of the evidence that the Crown put forward. It was all subject to cross-examination, and we didn't feel that there was anything that needed to be added to the body of evidence that the judge is going to consider, keeping in mind that the Crown has the burden of proving beyond a reasonable doubt the charges that they have made out. And we look forward to making final submissions on the basis of that evidence.
As far as the outstanding dates, the pending dates in August, I'm asking to speculate a bit, but you expect that to be sufficient to conclude proceedings?
We should be able to get final submissions done in 8 days. My goodness, they do murder trials, submissions in final submissions in a couple of days. I think 8 days should be enough for us to complete this matter.
And last question, as I was saying to earlier, I just want to see if I understand this correctly in terms of the practical impact of the decision by the judge to reject the defense team's request to bifurcate the Carter application decision from final submissions. The bottom line is, for the audience out there, that just means that both you and Diane Magus have to prepare final submissions for either scenario. It's just more homework as legal teams. Is that fair to say in layperson's terms?
Yes, I think that's a fair way of putting it. Ultimately, what it means is that we won't have the benefit of a ruling from the judge on the Carter application, so we won't know whether that evidence, that body of evidence, is going to go in whole or in part or not at all. And we'll have to prepare our final submissions with that in mind.
Chris Barber and Tamara Lich trial is now on temporary hiatus. It will resume in August. So the scheduled dates as of now are August 13th to the 23rd. So stay tuned with us. We'll be here to cover that when it continues. Dear Rebel News audience, please remember we depend on your donations, your contributions to keep producing this original in the field journalism that we hope you appreciate and value. So please visit tamaratrial.com, help us out as you can, and stay up to date with our ongoing coverage.